We've all heard about families quarreling over the disposition of personal property, but there are solutions, and we have a couple experts with us. Today, to my left, Marshall Besikoff, and to my far left, Sidney Kaplan. Marshall, I'm going to read this because I want to be sure I get it right here. A CPA, partner in the accounting firm of Lurie, Besikoff, and Lapidus, and Sidney, a partner in the law firm of Parsinen, Kaplan, Rosberg, and Gotlieb. Those are very impressive credentials. And I know that you guys have spent a lot of your time dealing with family issues. So, since I've made the promise that you've got some solutions, let's start. I think we're going to do it this way. You tell me some of the major problems that you've dealt with, Marshall, and then Sidney, you'll come in and talk about some of the common solutions that you use either on a legal basis or on a common sense basis. So Marshall, we'll start off with you.
Great. In the 40 years that I've been practicing, I find that by the time people are seniors, they have wills and trusts and think they have an estate plan.
Now, the money primarily, the disposition of money.
And that's dealing with money. But what they really don't have are, one, up-to-date documents, because facts change and laws change. And more importantly, they haven't decided who's going to get the art, the jewelry, the collections, the pets, and the
the pets are significant, right?
Right, and memorabilia. And even in my own family, when my my grandmother, who was in St. Paul, and we lived in St. Paul, had a fireplace station that was from the old country, a bronze fireplace piece, and my brother liked it, and she said, well, you can have this when I pass away, so he took it. My uncle, who was living in California, didn't realize that had gone on, and they didn't talk to each other for 2 years afterwards, and I call that the Cold War. And then I have other relatives who had jewelry, and that wasn't properly dealt with, and also involved some second marriage consequences, and the jewelry went in the wrong place, and I call that the hot war. Then we had some other relatives that had some artwork, 3 pieces of artwork, and they said, well, each one will get 3, and I said, well, go have it appraised. One was $200,000, the other 2 were $10,000. That became the money wars. And last but not least, I've seen a number of families where the memorabilia became the most important thing, and that I've always referred to as the beginning of World War III in a family.
And you mentioned that different matters, different situations create additional problems. One thing with a marriage, a second thing with a family that husband or a couple living together, or a single man. There's a lot of different...
Right. Almost everyone becomes a widow or widower, and then has a new life, either gets married or has other arrangements, but they all acquire property, and all those properties have to be dealt with so that it comes out the way they want to have it come out, and that's where I call Sid and say, what do we do now?
Okay, now the CPA is giving way to the attorney. Of course, you've resolved these problems too, as in your CPA category.
We identify the problems to make sure the client knows what they don't know and gets them to see their lawyers to make sure that they get the legal documents handled appropriately, but we don't practice law.
So now we turn over to the attorney. Here we go, Mr. Kaplan.
And there are some very easy methods to try to maintain harmony in the family, either with a second spouse or amongst the siblings in these multi-generational conflicts. First and foremost, Minnesota, as most states in the country, have and recognize something called a tangible property letter or memorandum. This is a letter or memo that you can prepare yourself, fill it out, and it does not need formal execution before a notary or with witnesses. You can list and describe the items of personal property and who is to receive it. You can even designate a contingent beneficiary if that person dies. And so long as you date and sign it, it is a valid, legally binding document.
Okay.
And there are variations on this. I mean, many clients just do this simply and list the items. If there are extensive items and extensive collections, you can frame this letter into classifications and set up a round-robin system for the siblings or the friends or the family members to select in a proper order until all of the property is chosen. Another way of doing this, and often will suggest this to the family. And in my own family, this is what was done by my father, who was a surviving spouse. When he knew he was dying, he came out from his bedroom one afternoon, and my sisters and I were there. He handed us a sheet of paper and a pen, and he said, "Divide the house up, because I want you to make the decisions. If you can't, then I will do it." And so my sisters and I were given the task of trying to resolve our differences and divide the household up. And when we agreed, my father had it transformed into a tangible property memorandum, and it kept peace and harmony in the family. So using a variation on this theme solves lots of the problems.
Let me ask this question now. We've had a number of alternatives here. If in doubt, is the family better off by going to an attorney? And does it take that long? Is it very expensive just to do a couple of papers?
To do a tangible property memorandum is not costly or expensive at all. And there's a format that we can furnish the clients with. Obviously, in most cases that we're involved in, it's part and parcel of an overall estate plan where you incorporate the tangible property. One other important item is often in families, there'll be one major item. You know, the Picasso drawing that the family bought in Europe 50 years ago, or the 10-carat diamond ring. How do you divide that up? And again, through a proper memorandum, you can direct its appraisal. You can provide that whoever gets it has to buy the share at the appraised value of the other siblings, or you can direct its sale. And then the final arbiter of this should be your trustee or your executor.
So you need a trustee. Can a trustee should the trustee be a non-family member?
If there's a potential for any conflict, you want an independent trustee or personal representative who has the ultimate authority to distribute this property or to sell it all to avoid family conflict.
Okay. Should the trustee be an attorney that's in the family, or should it be totally?
It can be an attorney, it can be an advisor, someone like Marshall. It can be a close family friend who's independent. It could be another relative who is not a beneficiary, but someone who truly has no stake in the distribution of the property.
We're almost done. Do you have a final comment to make?
Everybody is acquiring something every year. You should make this an annual update process, because the last things that aren't dealt with will also cause the problems that the ones that have been dealt with no longer cause. And the ultimate estate plan that we want to be proud of is one where there is no family conflict.
And
Guys, thank you.
Every scenario, we pass these out. So it's dealt with.
This is very helpful. Thank you very much.
Thank you.
Been talking to two authorities, Marshall Besikoff, Sidney Kaplan.